Hi, I'm Cooke Hutchinson, Legal Practice Director at Cooke Hutchinson Lawyers. Today I want to talk to you about the standard real estate institute contract where you're either buying or selling a home. There are two very important clauses in those contracts which deal with finance and billing and pest. Many buyers think that that clause is inserted for their benefit alone, and that if they decide not to proceed with the purchase, they can simply say that their finance hasn't been approved, or in a billing and pest case, they can say that they're not satisfied with the billing and pest report. Firstly, dealing with finance, there's a very famous case that was decided in the High Court over 35 years ago, which said that a buyer must act reasonably. So if you don't make the application for finance and you don't take every endeavour to obtain finance and you attempt to terminate the contract, that can have very grave consequences for you as a buyer. The seller can treat your conduct as being a repudiation of the contract and can terminate the contract, claim your forfeiture of the deposit, and also sue you for damages for breach of contract. And that's not limited just to the deficiency in resale price. In relation to billing and pest inspections, the clause places a positive obligation on the buyer to have an expert go and do the billing and pest inspection. If there are what we call latent defects, that is something that you could not have seen when you inspected the property, and it is a substantial thing, then you would have the right to terminate. If it's a patent defect, something that you should have seen when you looked at the property in the first place, like a rusty gutter or something of the like, you won't be able to terminate the contract. Again, if you do attempt to terminate the contract and your conduct amounts to a repudiation, the seller again has the right to terminate the contract, forfeit your deposit and claim damages for breach of contract. So I urge anybody out there who's signing a contract to buy property, especially a dwelling house where you've got building and pest involved, or even on a block of land where you've got finance involved, that you make sure you do act reasonably. The High Court has said that you must do so, and if you don't, you run the risk of getting into fairly significant trouble financially. If you have a situation where you think you've been aggrieved in relation to a finance clause or a billing and pest clause and you need legal advice on it, we at Cooke Hutchinson are happy to look at that for you at a fixed price. Thank you.